Hey, Jeff Reber over at ERA Real Estate here with Kellen Bryant, who is both a friend and a business associate. And Kellen's the owner and attorney at Berg Bryant Elder Law Group. And, well, Kellen, how long have you been an attorney now?
Hey Jeff, thanks for having me on. I've been an attorney since 2007 and I've had my own practice since 2009, so
Yep.
2 years out of the gate of law school. So I had we have a similar path for anyone who doesn't know, of starting a business in our mid early 20s
Yeah.
and during a recession. So we suffered together, and
Okay.
I've been doing elder law since 2009, which includes dealing with estates, estate planning, and so forth.
That's right. And then Berg Bryant Group or Elder Law Group, that was how many years ago now?
Yeah, so I started off as my own law firm for about 7 years,
Yep.
2009 to 16. And then I joined with attorney Rebecca Berg, who is the basically first elder law attorney in Jacksonville, Northeast Florida. And she is like the preeminent expert in this stuff and creator of a lot of cool stuff in our field throughout her career. And so she was ready to retire, and we joined forces. And then she's retired, and so now it's back to me being the head honcho again of my of the firm. So
Got it. Yep. And I thought I'd let you spell out those details because I know them, but not as intimately as you know those details. So yeah, thank you for filling in the gaps. And today's topic, and the reason we're talking to Kellen, is dealing with legal issues related to a loved one's house and how to help them best kind of seamlessly move through the process, whether this loved one has passed away or you're getting them into like an assisted living facility or just helping them plan for like what is to come essentially. So I guess first question, Kellen, is let's say you're dealing with a family member's home and they've passed away, and you're trying to navigate all of the hurdles associated with cleaning up all of the legal issues that are now attached. How do we go about doing that?
all right, great. So first off, when you use the term loved one, leading into this question for anyone, it could be a son taking care of a parent, a granddaughter taking care of a grandparent, a brother taking care of his brother, a disabled child living in the parent's house, cared for by another sibling. Caregiving and dealing with somebody else's real estate is can happen, and so there's many, and when you're dealing with the real estate, the legal approach depends on the context. And so in your question is what happens if your loved one has passed away. So the process depends on the titling of the deed. So in most cases, husband and wife own a property, husband passes away, wife now owns a property, wife passes away. And so when it's a joint property, the survivor spouse gets the property. But when the surviving spouse passes away, then what? So if there is a will, the will would control what would happen, and the will is your ticket to probate court and the entry to the probate process that will be required to sell that real estate. Without a will, you still go to probate, but the state of Florida gives you your will. Essentially, it's basically, if you don't have a will, here's the default where your real estate's going to go. Sometimes it's going to, as a general thing, it gets divided between your kids equally. If you don't have kids, then it's going up the family tree. So if you have a brother or sister you don't like, and you have no kids or a spouse, then you need to think about a will, because your brother and sister you don't like is going to get interest in your property.
Let the record show I do like my brother and sister, though. This was not a just kidding.
Yeah, your brother and sister are great. I've met them both, so you won't have that problem. But not everyone is as fortunate. So the deed, presuming that the deed is, there's just one name on that deed, it has to go through this probate process. And the probate process in Florida is a way of clearing title to the rightful owner to sign those closing papers, to sign that deed to the buyer. And it's like a clearinghouse process. You cannot sell the house without this process because no title company will insure the sale, unless you're buying it as is without title insurance. And then in that case, the buyer may be really taking you for a severe discount if they're even wanting to close. So the probate process has to take place, which is a lag in selling the process or selling the property. So in that case, how long does it take is a common question. It depends on the parties involved, but to get that house dislodged from probate to be able to sell typically takes anywhere between 3 to 6 months. In Duval County, where Jeff and I are located, we currently have great judges who will give authorizations as a workaround between not having to wait this 4-month period, 3-month period. That's how the judges currently interpret the law here. But it can vary from county to county about selling primary residences really quick after the death of a loved one. So this process would be the general process that you would need to lead into and know that's coming if you're looking to sell your loved one's house. And because of this time turnaround, a lot of people are not ready to if it's a shock that somebody's passed away, or we weren't prepared, or you weren't able to get to the house enough. You can use this time to clear up the house and of the personal items. And now. And one of the things I always punt to is when I'm having these conversations, 2 weeks after someone passes away, is what's the condition of the house. Sometimes the person hasn't updated it in 30 years, and sometimes there's 30 years worth of stuff inside the house. Jeff, and I always say you need to talk to your realtor about that. Jeff, I'm just curious, what would you say to somebody?
Yeah, absolutely. And so, obviously, if you're going to sell the property and it either needs extensive repairs or has tons of stuff in it, which I've seen often, that's not really ideal for taking it to the market, because what you can end up with is if you go to market, it needs a bunch of repairs, it has a bunch of stuff in it, you have a maybe buyer who's wanting to purchase that type of property for their primary residence, not realizing A, what the real costs of all of the fix-ups are going to be, and then B, that they may have trouble getting financing, getting insurance. And so I've seen where somebody in that situation just throws it on the market only to be upset when a buyer comes along, makes an offer, accepts an offer, deal falls apart, it ends up sitting for a while, nobody's happy and excited, and things go poorly from there. So I always say, let's give a real estate broker, agent, realtor a call beforehand, give me a shout beforehand, and let's talk through the process. Who's the most likely buyer? What do you have as a budget for renovations? How are we going to prepare it for sale to go on the market, or potentially find somebody that will just take it as is and still give you a competitive price off of the market? Those are all things that end up falling in my lap after they've talked to Kellen about the process for legally selling it. And as a quick aside, obviously today we're focused on real estate specifically, and the real estate aspects of probate and the like, not bank accounts, investment accounts, maybe other asset classes that your loved one might have. So that'd be an entirely different conversation, and one that you just need to call Kellen for at that point. So, yes.
Yeah, so I think that's interesting. Definitely an interesting point. And what I try to do in our consultations when we start is try to identify the likely beneficiaries of the house. And the main thing I want to convey is the likely benefit is a mindset thought, because essentially the beneficiaries of an estate of a deceased person are the stakeholders in the sale of that property. They're almost like business partners. And so the decision how to sell the house, when to sell the house, what to do with the house, is almost like you're in a default business partnership with your siblings or family members about what to do with this house. And so there needs to be definitely a meeting of the minds in the family about what to do with the house during this pendency period that we have to think through with the probate. Now, on the other piece that I wanted to mention is dealing with the personal items in the house. Usually the will governs that. If no will, again, it's going to be split between the legal heirs, and that depends on if the person had a spouse or children or none. So that those in getting the stuff out of the house, dealing with the stuff in the house, sales and all that, those are all little things that need to be discussed between myself as your attorney and your family members to see what's the most practical approach with the stuff inside the house. But ultimately, the best starting with after the first attorney consultation, that's the best time to start game planning for addressing the real estate and the stuff in the house so that there's no unnecessary delay, because we're already in a period of delay going through the probate proceeding.
Right. No, that makes sense. And it's a lot to digest, and certainly a lot to digest when you're in the middle of that. So let's talk about the sort of preemptive strike. So what we've talked about up until this point is that we're dealing with a loved one who's passed away and what they have for real estate holdings. So let's say I have a loved one who I'm trying to help them get moved out of their house and preparing it that way, either just functionally or legally. What do I need to think about, and what are the different scenarios that you see most often, and how do you help people sort of walk through that?
Okay, there's a bunch of layers to that question. When you have a loved one in a house and they're unable to fully care for themselves independently and live life comfortably independently. So first, if they're refusing to leave, you got to get over that problem. There has to be a discussion about involvement of doctors, other people, neighbors, and so forth. Not even focusing on the value, what's happening to the house, which is neglect most likely, but for the care of your loved one, and getting through that process of determining, are we going to move? Are we going to go to assisted living, nursing home? Are we going to go to a daughter's house and live at the daughter's house? Or is the daughter going to come live with you? So those humps need to get through. We need to get through before we go anywhere.
Right.
Also, one of the most important legal humps to cover is the durable financial power of attorney. So if my parent becomes mentally incapacitated, my parent cannot sign the closing papers legally and understand the closing papers legally to actually sell the house. And without a durable power of attorney, I cannot do that for them. I have no legal authority as son to sell a parent's house out from under them without their knowledge. They need to sign that as paperwork, or we need to have a durable power of attorney in place. In the absence of a durable power of attorney or a poorly worded internet durable power of attorney that does not permit the sale of the house because of improper wording of the document, then if the person cannot mentally sign their name and understand what they're signing, then you need a court-supervised guardianship to sell the house. And have the guardianship court to approve the sale of the house. And what you'd be looking at is at minimum $12,000-$15,000 of legal fees to accomplish that task, in addition to all the other fees and costs associated with moving. So if you're watching this and you're starting to care for a loved one, you need to look at the durable power of attorney if you're the one to sit at the closing table to sell the house. And in my opinion, getting resistance on the issue is a hurdle that you also need to work towards getting over. Because if your loved one is saying, I'll sign it when I need it, well, when you most need the durable power of attorney is when you're incapacitated. And if you're incapacitated, you cannot sign a durable power of attorney. So that is a critical step if you are early in your caregiving journey, is to get a properly worded durable power of attorney, preferably, depending on your net worth, even one that allows for Medicaid-based planning to protect assets. Now, if we're going, depending on where we go in the care of your loved one, this is actually a major financial decision, because if your loved one needs to go to a nursing facility, which is a licensed term, versus an assisted living, which is also a licensed term, there could be Medicaid issues raised. A house in Florida is protected, unlike many other states, protected from Medicaid liens as long as it remains as your primary residence. But when you sell the house, it becomes cash that is not protected in this Medicaid process that could require a spin down. So a very detailed discussion needs to be had about what to do with the primary residence and what seems most logical given the condition of the house, condition of your loved one, longevity potential of your loved one. Maybe you can bring in market conditions about, hey, is the market up? Is the market down?
Right.
Rentability. Is there family members who can be caretakers of the house that are successful, that can be successful in the matter? A lot of issues come into play when you're wanting to move or sell a house as a result of needing care. And that's when that's a very common circumstances where a lot of people talk to me, and we work through that process, and it depends on what your care wishes are as well.
Got it. That's a lot to think about. And so I don't know that I have any further questions on that because you covered a lot of ground quickly there. Obviously, if you're watching and you have further questions, we'll get to at the end Kellen's contact information so that you can reach out to his office. But another question, kind of taking it a step backwards, even still or even further, is, okay, so there's no issues that we see coming. Maybe this is for loved ones, family members, or maybe this is even just for ourselves. How do we properly put the pieces of the puzzle together so that we can allow those who care for us maybe to seamlessly move through the process whenever the time comes to figure out what to do with somebody's real estate and how to help them through it. So how could I be best prepared, I guess, is the question.
So, and I think we should, I'll just continue on based upon the caregiver situation where,
right,
the loved one's still living, and then we can go talk about what happens,
perfect.
How to plan for death a little bit smoother as well. So and I did get into it preliminarily, was saying the most essential thing is the durable power of attorney. If your loved one's unable to sit at the closing table and sign all the closing documents, there needs to be legal authority to do so. And if your loved one's unable, due to mental incapacity or even physical incapacity, unable to sign with any degree of legibility that passes title insurance desires, you need to have a durable power of attorney. And I said earlier about the wording really, and I disparaged online durable power of attorney documents. The wording really matters. It's like there's little legal traps in that dense, single-spaced, 10-point font language of a durable power of attorney that has to be in there for somebody to sell somebody else's house. Okay. That would be the power to convey. That needs to be said in the document that your agent can convey real estate. Next, if we're keeping the house and we're looking to maybe avoid probate, there needs to be additional language about gifting powers, naming beneficiaries on the deed through what's called a ladybird deed. And I see those are planning measures that needs to be included in the document. Yes?
Pause on that one for a second. I come into contact with ladybird deed language fairly often. What is that? Give us the 30-second overview of what a ladybird deed is and does.
So the word ladybird is a Ladybird Johnson. That's where it came from, ladybird. I've heard of people say other things. And by the way, it's quit claim deed, like I quit, not quick,
not fast.
Claim deed.
Yeah.
Yeah,
quick
not
like
fast.
I'm over it, not quick like fast.
Yeah. Yeah, it's a funny game of telephone that we get sometimes in the office, so it's quit claim deed. So the Ladybird deed language is basically saying that my house right now, Kellen's house, I'm signing a Ladybird deed. I am the owner for life, and when I pass away, it goes to X or X, Y, and Z because I have 3 kids. So that and the difference between, and that's called a life estate if I just have that language. The Ladybird deed is a little bit different, that allows that there is additional language, big chunks of language that says basically I can change my mind about my beneficiaries on the deed. Just like you can go to a bank and name your children as POD, pay on death, and then say, well, I'm mad at this son, I'm going to take him off and put my other son on there. Theoretically, you can do that with a Ladybird deed with some exceptions. to those rules without having the son to sign the deed himself to get his name off the deed. So which won't happen, of course. So Ladybird deed it's also known as an enhanced life estate deed. If you're doing any kind of internet research, and it's a probate avoidance tool. Basically, when you sign the Ladybird deed, if all goes well, the person named on that deed as a remainder owner records your death certificate at the public records in the county where the property is located, and they're now the owner, and they can close the very next day after they have your death certificate. So it makes the process it skips the probate process.
Got it.
So
cool. Yep. All right. So sorry.
Yeah.
So
going on the long-term care planning with somebody who may be going into a facility, having a family conversation about where someone receives care and how they receive care, and having relevant stakeholders like the children or likely beneficiaries is kind of a key step because most of the times, as you're aging and you're saying, "Whoa, maybe I can't cook a meal or deal with my bills or feed myself, or maybe I'm having trouble taking a shower because my shoulder hurts so bad I can't reach my shoulder." Like those type of things, when those things start occurring, or maybe you shouldn't be driving, there needs to be honest conversations about how you want to be cared for, and realistic conversations that don't include just leave me in the woods and I'll figure it out. That's not a realistic conversation.
Right.
Most of the times. How about all the times?
Yeah.
So there needs to be real conversations about what do we want done in this process. Some people say I don't want to be a burden. Most people say I don't want to be a burden on anybody. But that requires. But if you're wanting to be at somebody's house to get your care, and they have to quit their job to take care of you, is that a burden? So you need to have real conversations between all the stakeholders about what to do with the house if somebody's unable to live there by themselves. And maybe the caregivers that you bring in aren't sufficient. Maybe they're not doing the job. Maybe whether it's a service or whether it's family, maybe you just have too much needs. There needs to be real discussions about, hey, when does the decision need to be made as a planning perspective? Of course, we need to have the legal documents in place, such as a durable power of attorney. Maybe even a trust might be helpful, depending on somebody's total assets, and family situation and family dynamics. So those are the really key helpers to avoid that really expensive and time-consuming and frustrating and onerous guardianship when you're aging. And usually the guardianship may not just occur because you don't have the documents. It may occur because you have two kids and they can't stand each other, and they're trying to get you to sign in a decreased mental state new documents over each other and trumping each other, or the person with the document is choosing choice X, and then the other child says, no, that's not what mom would have wanted. Things like in that, is that child acting out of self-interest or interest from mother? Those are the kind of issues that need to be weighed through and considered before we do anything. Sometimes it's easy. Sometimes it takes 10 seconds. But sometimes it takes a lot of work and rationalization to figure out what to do for yourself as you age.
Got it. No, that makes a ton of sense. And I know you've got appointments coming, so we'll start to wrap up here. And then if this scenario or situation is, God willing, a long ways off, how do you think about, somebody in their 40s with home assets, whatever, needing to prepare? What are the quick bullet points on anything that person should be thinking about?
Depends. And whether it's just a 40-year-old or even just planning for death, it's going to happen to all of us at one point.
Right.
So, when you do it, depends on your budget, your time availability, and maybe your medical condition. I am 40. I just turned 40 in July. I can have an accident anytime, even though I know I have a pretty good current bill of health, because I always have an accident. And so it's always important to And if I was tight on budget, maybe I can take. There are legal options that might be more budget friendly, and so forth. And so, but depending on your real estate holdings, maybe and the capability of your loved ones to manage your real estate holdings, trust sometimes helps, because a trust gives you a little bit more time to deal with the assets, or allows you to name somebody with higher levels of ability concerning those assets. So if somebody has complicated commercial holdings, for example, and the spouse has no desire to learn how to manage a commercial property or deal with the commercial property or know about the tax issues associated and timing and financing and things like that, or zonings, all the other issues associated with commercial property, maybe that might be a reason to think of having somebody sophisticated in those matters settle an estate and using a trust.
Yep.
That might help. For multiple real estate holdings, it may help, because what will happen is, with a revocable living trust for the 40-year-old or even 65-year-old healthy person, the revocable living trust avoids the probate process and allows you, the creator of the trust, to provide some direction to your loved ones and to your trustee about handling your assets. If you have this specialized knowledge and you're wanting to leave all your property to your children and none of your kids know anything about real estate, then having your wishes and desires and knowledge spelled out resolves any kind of questions that the beneficiaries may be facing. Usually most reasonable people, hopefully if you're listening to this, you have children, you're a reasonable person, and you've raised reasonable people. Reasonable people, if they see your instructions in writing, they'll just follow the instructions, and versus two people saying, no, Dad wanted this, Dad wanted that. And it has it all spelled out in writing, and it avoids and you also avoid the whole rigmarole of a legal process called probate. So it helps with trusts help with decision-making process, and it avoids a onerous legal process. A lot of times, even with a trust, it sometimes is one meeting with me, here's what you do, never see the person again, when I have good family situations.
Right.
So for somebody looking to decrease those headaches, trust is a pretty good thing.
Good stuff. And last but not least, we'll wrap with this. So if I'm Googling around and I'm trying to figure out, helping a loved one with estate planning or with their real estate or whatever the case may be, what is different in Florida that I may land on some random web page that could confuse me if I'm dealing with something that is real estate located in Florida, which is probably most of who's watching. Anything different about Florida that when I'm searching the internets, I would stumble on and maybe not know if it only applies in other states?
So in Florida, we have this thing called homestead. Everyone, if you're in Florida and you own a house, you know about homestead. It's that discount off, one type of homestead. It's that discount off your property tax bill. But homestead plays a lot in the homestead laws of Florida, play a lot of different roles in what you can do with real estate, and what somebody can do. The homestead laws in Florida make it so married couples, if the house is just in one spouse's name, both spouses have to sign to sell the house or deal with the house.
Yep.
So second marriages, this comes up quite often. If we got married, I sell my house and my wife already had her house and I move in, but she never adds me to title. If I become incapacitated and I don't have legal documents, she can't sell the house or refinance. So even though my name is not even on title, it's because of the homestead laws. So that's one element of homestead. You need both spouses to sign things when the property is one spouse's name, or in both spouses' name, of course. Number two, Florida has a creditor protection in real estate where if I owe $1 million in medical bills because I had a catastrophic injury, the medical collectors and medical providers can't force the sale of my house to pay my medical debt. So that's another element of homestead. And then homestead laws in Florida also restrict those creditors when I pass away. As long as I leave my property to heirs, then that debt protection that the homestead gets is also allowing my house to pass free and clear of creditors to my heirs. So because of those elements of homestead and homestead protection come legal restrictions. Another legal restriction of homestead, by the way, is if people pass away and and there's a minor child, and if the house is not titled jointly and there's a minor child, the property could end up going not the way you want. So usually with second marriages, primary residences, where both spouses are not on the title, that's the biggest thing you need to watch out for in your estate planning with your primary residence, and that you will not see in most states.
Interesting stuff. And you're absolutely right, because I talk to people around the country, especially as we've had sort of a mass move to Florida, and some of the homestead protections in Florida surprise people in a good way, because I think for the most part these are all good things if you own real estate as your primary residence. So Kellen, this has been great. I greatly appreciate the time. I know the viewers will as well. So if somebody has questions about anything that we've talked about, how can they best get in touch with you?
So I have plenty of additional information on the web. So if my weird name appears on this video, Kellen Bryant, K-E-L-L-E-N, Bryant, and Kellen Bryant Attorney, you'll get a bunch of stuff. I think I'm the only one in the United States. Who's an attorney named that. The benefits of having a weird name. So So if you're looking to take action and you wanted to work with me, you can call the office 398-904-398-6100. And usually the process involves, talking to a paralegal, which is almost a free consultation to see if we can even help you if we're relevant. But to meet with me, there is a $500 consultation fee as of the date of this recording. I've been working on a consultation fee basis for about 8 years now. So there is a consultation fee, and usually it's a consulting fee essentially to figure out what exactly to do regarding any of these issues. And from there, if there's additional legal work, we'll price it out and figure out what needs to be done. But it's always done from the perspective of what do you want? Here are the options you have. How do you want to approach it? And each approach has different costs associated with that. So that's probably the best approach to deal with me. And if you still have some questions, I have plenty of information on the web that's free that you can find, whether it's on YouTube or on my website.
And Kellen does, and he's great about putting content online that it will at least help point you in the right direction for answering the question that you have, so that you know how to reach out to him or someone else whenever you do need a problem solved legally. So Kellen, thank you again. And if anybody needs to reach out to me, Jeff Reber, it's Jeff, Jeff, @ERA.com, or 904-405-1995 for real estate related stuff. And Kellen, I will let you get to it. Have a great week, and we'll catch up soon.